co-chair, along with Member of Parliament Michael Barrett. Bon après-midi et bienvenue à...
Good afternoon and welcome to this meeting of the Special Joint Committee on Medical Aid in Dying. I would like to wish a warm welcome to all the members of the committee, to the witnesses, and members of the public watching this meeting on the web. I'm Yona Martin, and I'm co-chair of the committee.
I'm hearing both you and the interpretation simultaneously. I don't know if anybody else is experiencing that as well.
Yes, I have it on English. You're right. So I shall remember to take that off. Thank you. Sorry about that.
No, it's okay.
But I think everyone did hear the echo and heard me nonetheless. So I will continue. But is Mr. Anand Dasanguri here this time?
Thank you, Madam Co-Chair.
Okay, today we are starting our exam. Yes. We're not hearing the sound in the committee room, so I'll just continue for now. Today we're starting our examination of the criminal code relating to medical assistance in dying and their applications. Before we begin, I'd like to remind members and witnesses to keep their microphones muted at all times. We have had a few technical difficulties already, unless recognized by name by the joint chairs. A reminder also that all comments should be addressed through the joint chairs. When speaking, please speak slowly and clearly. An interpretation in this video can work like an in-person committee meeting. You have the choice at the bottom of your screen of either floor, English, or French. So with that, I would like to welcome our witnesses. From the Department of Health, Abby Hoffman, Senior Executive Advisor to the Deputy Minister. Jackie Lemaire, Senior Policy Advisor, End of Life Care Unit, Strategic Policy Branch, and Venetia Lawless, Manager, Care Unit, Strategic Policy Branch. From the Department of Justice, Joanne Kleinberg, Senior Counsel, and Jay Potter, Acting Senior Counsel. Thank you all for joining us at this important second meeting of the committee. We'll begin with opening remarks shortly by Ms. Hoffman, followed by Ms. Kleinberg. And each of our witnesses today have 5 minutes, and I do have a stopwatch next to me so that for all speakers, I will be timing, and I will try and give you a 30-second warning before the end of your time. And with that, I would like to invite our first witness, Ms. Hoffman.
Madam Co-Chair, I do have a point of order at the outset. If it'll
Yes.
take very briefly. I would like about 15 minutes at the end to discuss committee business. So I'm very appreciative of the witnesses that are here, so I don't want to delay it at this point. But close to the end of the meeting, Mr. Barrett and Ms. Martin, if we can have about 15 minutes at the end to just finalize committee business.
Noted. And so we will begin then, thank you, with our first witness, Ms. Hoffman.
Thank you, Madam Chair, and good afternoon and good morning to all of you. When I addressed the committee last year, I drew on the government's annual report on MAID to provide a statistical overview of assisted dying in Canada. You have access to our latest report for the calendar year 2020, so I will note just a few key points at this point. In 2020, 7,595 individuals received a medically assisted death, accounting for 2.5% of all deaths in Canada. This reflects steady and expected year-over-year growth. MAID procedures, as a proportion of all deaths, will likely level off at approximately 4%. Since the inception of MAID in Canada in 2016, the average age, 75, most frequently occurring medical condition, cancer, percentage of written requests resulting in a MAID death, approximately 75%, the urban-rural split equivalent to population distribution, proportion of requesters who have accessed palliative care, slightly more than 80%, the most common manifestation of suffering reported by requesters, their serious diminished quality of life, including inability to manage activities of daily living, and the proportion of provider-administered versus self-administered procedures, more than 99%, have remained more or less constant. We know the picture of MAID in Canada will evolve over time in light of the changes authorized in Bill C-7. We won't have comprehensive data available in the time frame of your review, but we have some insights from preliminary data for 2021 and anecdotal sources, including the following. The number of MAID cases continues to increase, approaching 10,000 in 2021. Despite COVID, this was approximately a 30% increase. Around 2% of those cases, or just over 200, involve persons whose natural death was not reasonably foreseeable. As expected, these individuals are slightly younger, and their predominant medical conditions are much more likely to be neurological in nature, such as Parkinson's and MS or chronic pain. We have been working on the new regulatory requirements for the provision of data about MAID, and these will be in place by January 1st, 2023. The new data will document MAID cases where the requester is not facing imminent death and cases where a requester approved for MAID has made an agreement with the provider for a waiver of their final consent. The new regulations will also ensure reporting on the application of the strengthened safeguards that apply to cases where the requester's natural death is not reasonably foreseeable. These include consultation with an expert in the person's condition, the offer of available services and supports to relieve the person's suffering, an agreement by the provider and the person requesting MAID that the person has given serious consideration to these means. And we will be authorized as well to require providers to collect and report information about the requester's race, Indigenous identity, disability, and other characteristics, providing the individual consents. And this will help establish the presence of any inequalities, including systemic inequality in Canada's MAID system. Just a few words about cases where natural death is not reasonably foreseeable. These cases are challenging because of the complexity of each requester's circumstances, the need for clinical analysis of each element of the eligibility criteria, and the application of rigorous safeguards. We have heard from some practitioners that doing these assessments is extremely difficult, which we anticipated. So to facilitate consistent and safe application of the new legislative framework, Health Canada is funding the Canadian Association of MAID Assessors and Providers to develop resources for MAID practitioners. Over the next 4 years, CAMAP will develop and disseminate a nationally accredited MAID curriculum, which will provide high quality in-person and online training for providers across Canada. And modules will cover such topics as assessing for capacity to give informed consent, vulnerability, navigating complex cases and conditions, and MAID in the context of mental illness. We anticipate this training program will help ensure high quality services for Canadians and support the recruitment and retention of participating health providers. I can speak further. Yes, thank you. I can speak further about research that we will also be supporting to complement the federal monitoring system. We also want to review the various approaches to MAID delivery and oversight adopted across Canada to identify challenges and successes, which can then inform policy and planning. Along with my colleagues, Madam Chair, we will be happy to respond to your questions about MAID generally or the specific subjects of your review. Thank you.
Okay, right on time. Thank you, Ms. Hoffman. And I know that you brought a lot of expertise today. So we will go into our first round of questions, which will be for 5 minutes each. We'll begin with Mr. Cooper for the opposition Conservatives, followed by a member of the Liberal Party. So I'm
Madam
curious
Chair,
as to
order.
which. Yes.
I believe there are other officials. There's at least one other official that's able to do a presentation.
I apologize. I was too eager with the round one. So you're right on the next witness for the speech. Thank you.
Good afternoon, and thank you, members of the committee. My name's Jay Potter, and I'll be giving remarks from Justice Canada today, and I'm pleased to be here to support your review of medical assistance in dying. My comments will be consistent with those of Ms. Kleinberg's from last year and will provide an overview of the federal MAID framework and highlight some considerations that you may wish to bear in mind as you study the complex and important issues that are before you. As you know, our law has evolved considerably since the 2015 decision of Carter by the Supreme Court of Canada. In less than a decade, the law's approach has transformed from an absolute prohibition on MAID in all circumstances to a sophisticated regime that permits it as a legitimate response to intolerable medical suffering, while also providing for eligibility criteria, procedural safeguards, and a monitoring regime to protect vulnerable persons. Thousands of Canadians have accessed MAID, most of whom under the initial framework set out by former Bill C-14. And as you all know, that framework changed last year through former Bill C-7, which responded to the Truchon decision. The most significant change made by former Bill C-7 was to eligibility criteria. The law now permits MAID irrespective of whether or not a person's natural death is reasonably foreseeable, but that concept is used to determine the procedural safeguards that will apply to a request. There's also a temporary exclusion for requests where a mental illness is the sole underlying medical condition, which will expire in March of 2023. There were also a number of changes made to procedural safeguards, including providing for a waiver of final consent, which allows MAID to be provided to an incapable person in certain defined circumstances, specifically where such a person has a reasonably foreseeable death, and while they had capacity, they requested MAID, were assessed and approved for it, had scheduled the procedure for a specific date, and agreed with their practitioner to receive MAID on or before that date if they lost capacity. As you move forward with your work, it may be helpful to recall that the framework governing MAID is shared between the federal and provincial governments. Parliament is responsible for the criminal law, which is the foundation for the federal framework, and the criminal code provides exemptions from offenses of culpable homicide and assisting suicide, so that practitioners and those who support them are not criminally liable for providing or being involved in the lawful provision of MAID. The criteria and safeguards form the key elements of those exemptions. In contrast, the delivery of health services is generally a matter of provincial responsibility. This includes organizing access to MAID, the regulation of healthcare professionals, and enforcement, whether that be at the professional disciplinary level or with respect to the enforcement of the criminal law. As a matter of health law, provinces or professional regulatory bodies could supplement the federal framework with additional requirements concerning MAID. However, they could generally not permit something that falls outside of the exemptions. That type of change would require federal legislation. Relatedly, I would note the issue of advance requests for MAID raises particular complexity in this regard. The criminal law exemptions are oriented towards a single point in time, which is when the practitioner administers a substance to cause a person's death, or provides them with a lethal substance for self-administration. In an advance request scenario, a second point in time is relevant too, which is when the request is prepared by the person who at that time is not immediately seeking MAID. This earlier point in time does not obviously involve the commission of a criminal offense that requires an exemption. So there's legal complexity in considering how the criminal law might provide for procedural safeguards or other requirements to govern it. Those would ordinarily be matters of health law. Finally, in support of your study, I would remind the committee of the 3 reports of the Council of Canadian Academies. These were prepared pursuant to former Bill C-14 and address many of the issues that are before you. No doubt you'll also be interested in the forthcoming recommendations of the expert panel on MAID and mental illness, which was established last year to consider safeguards, protocols, and guidance for the provision of MAID in those circumstances. Those conclude my opening remarks, and I'd be pleased, as well as my colleagues, to respond to the committee's questions. Thank you.
Thank you, Mr. Potter, and thank you for your patience as we continue. So our first round of questions, we will begin with Mr. Cooper for 5 minutes, and I will give a 30-second warning to all so that we can keep within our time, and followed by Mr. Maloney. Mr. Cooper.
Thank you, Madam Co-Chair, and thank you to the officials for being here. I was wondering as a starting point if officials from Health Canada or from Justice can speak to any data on issues of non-compliance with eligibility and safeguard requirements provided for under the criminal code.
Ms. Hoffman?
Yes, Madam Chair, I'd be pleased to make some initial comments on this. I guess the first thing I would say is that while we collect at the federal level data on virtually every aspect of the requirements that are set out in the criminal code, and we publish that, as you know, the responsibility for actual oversight of and compliance with the law is principally the responsibility of provinces and territories. Each of them has their own particular methods of going about this. In some cases, for example, the medical examiner or the chief coroner's office investigates or reports on every single case of MAID. In other instances, there is some sort of dedicated oversight or review committee. And in some cases as well, there are provisions of the medical regulatory bodies in the jurisdiction who also have a role. The number of cases of concern about compliance that we are aware of and that have been reported is very, very small. And the cases that we are the most familiar with, the provider in question who, just by way of example, one case involved somebody who, a practitioner who proceeded with a MAID case in an institution where there was concern about whether or not it was reasonable for that institution to allow that kind of access. That case, just as one example, was one of those that we know about where the provider and the provider's behavior was ultimately exonerated.
Well, thank you, and I apologize, but my time is short, but just to, and I appreciate your answer, but just very simply, is there national data of any kind?
No, there is not. No, there is not.
So what you're telling me when you say that you just said that non-compliance is very low, on what basis do you reach that conclusion, absence uniform national data?
That is based on reports from provinces and territories about MAID cases in their jurisdiction, and they have that responsibility for enforcement and compliance. So it would be natural that we would rely on data about their activities, which, as I say, in most cases involve a hands-on approach to every single MAID case.
Thank you. And you're not able to quantify, though, what very small is?
I would say, to our knowledge, it would be fewer than 10.
It's interesting because the Commission of End-of-Life Care in the province of Quebec, in its April 2019 report, ruled that 13 cases didn't comply with the law. And you're saying it's 10 in the province of Quebec. In the End-of-Life Commission report, they cited 13. I would further note that in Ontario, the Chief Coroner's Office announced a review of 2,000 cases in which the coroner, quote, raised concerns about, quote, compliance concerns with both the criminal code and the regulatory body policy expectations, some of which have recurred over time.
I would make a distinction,
that doesn't
Mr.
sound
Cooper,
like that doesn't sound to me like these are minor issues. I mean, at the end of the day, if you're not monitoring compliance in the law, what are you monitoring?
Madam Chair, if I can respond to that, I'll simply say that we are monitoring the practice of MAID in Canada, fulfilling our role as the federal government. Compliance, as I said, is the responsibility of provinces and territories. And I would also note that in the early days of MAID, and it's not to say that among some new providers this might not persist, there might be some administrative shortfalls. But this, if we're talking about whether or not a statement had the correct date, or the date was omitted, or something of that nature, then I think that I'm distinguishing in terms of cases where there might be some reason to believe
all
that
I
there
would
had
just
been a
say
significant
in the time
misstep.
that I have is that the number that you cited, 10, understates the findings of non-compliance in one province.
Well, I'm referring to serious non-compliance, not to administrative missteps that are inconsequential to the actual eligibility decision and the decision by the provider to proceed with MAID.
Well, I mean, the non-compliance was non-compliance with the law, and that law is the criminal code.
Okay, thank you, Mr. Cooper. And we'll go next to Mr. Maloney. 5 minutes.
Right. Thanks, Madam Chair. And thank you to both of the witnesses for being here today, for your presentations, and for everything you've done to get us to the point where we're at now, which I think Mr. Potter quite accurately pointed out is very complicated. I'm going to address two of the topics that we're dealing with, and that is the issue of mature minors and mental disorders. And the reason I'm putting them together is because I think one of the challenges in dealing with both of those issues they have in common, and that is what I'm going to call objective versus subjective assessment. Because in the case of a mental disorder, you have to, a medical determination has to be made as to whether or not the disorder satisfies the criteria. Similarly, with mature minors, somebody's going to have to make a subjective assessment, and I'm calling it subjective, maybe you'll disagree with me, as to whether or not the person is mature enough to make that decision. First of all, would you both agree that that's a fair characterization?
Mr. Potter?
Yeah, I might begin. So I guess one point where I might be able to assist is to point to if the committee was to look at expanding availability of MAID to mature minors, it would be open to the committee to also specify safeguards or conditions under which that would occur. And safeguards could address issues pertaining to capacity assessment, for instance. So just as the eligibility criteria as they exist now for adults provide, for example, that a person is only eligible if they've made a voluntary request for MAID and an informed request for MAID. And then there are safeguards, which are practical things a practitioner needs to do in advance of providing to satisfy themselves that the criteria are met. It would be open to the committee in looking at mature minors to think, given their unique situation as being underage, are there measures that might be appropriate for those cases to help give confidence that, for example, the person is capable of making that kind of very significant decision?
Thank you. Okay, so let's deal with mature minors then. I mean, but with an adult, you're dealing with informed consent, but you have the added layer of complication with a minor of determining whether they're able to make a decision and whether they can, whether they even know what informed consent is. That's the challenge. So I know that there are other countries where minors have access to medical assisted dying. I've looked at some of the statistics. The numbers, from what I can tell, are very, very low. So my question is there data available on the criteria that's used in those countries in making a determination of whether or not somebody is mature enough? And the second part of my question is there data available about the number of minors who have sought this the right for medical assistance dying and that have been refused, so we can get an idea of how well the criteria, to the extent that exists, is actually being applied?
I'm not aware of specific figures from the other jurisdictions you've referenced. It would most likely be places like Belgium, for instance, which provides that. There is certainly information that's more easily available regarding, for example, what the criteria are. So, for example, what the ages are, what the requirements are in terms of involving whether or not, for instance, parental consent is required, or if it's just a consultation with parents. Maybe getting back to maybe the first part of your question, too, there's the issue of, is capacity assessment subjective or objective? And maybe a way of looking at that is that capacity assessment, as I understand it in Canada, isn't that a person decides for themselves whether they are capable. It's an assessment that's made by the practitioners, which is an objective determination. Now, generally for adults, there's a presumption that someone is capable of making medical decisions for themselves, but if the practitioner has reason to doubt that, then they're able to engage in an assessment using various instruments to help validate whether the person has capacity to make a particular type of decision. So for mature minors, as an example, if that was something the committee was interested in exploring,
30 seconds.
Like I said earlier, they could you could look at whether or not there ought to be required elements in that kind of assessment.
Thanks. I'll pursue this further again, but somebody's going to have to convince me that deciding whether somebody's mature enough is an objective assessment and not a subjective assessment.
Thank you,
Madam Chair.
Maloney. Thank you. And our next questioner will be Monsieur Thérault. Monsieur Thérault.
Merci, Madame la Présidente.
Thank you, Madam Chair. Sorry, there's a little bit of a delay. So thank you very much. Thank you to the witnesses. I would like to begin with a very simple question for Mr. Potter, because he spoke about it when he was talking about the report of the expert committee. And do you know when this report will be tabled? This could help us in preparing our work plan.
Mr. Potter?
Madam Chair, if it's all right, I'd allow my colleague Ms. Hoffman at Health Canada to answer for this one.
Yes, go ahead.
Thank you, Madam Chair, and thank you, Mr. Theriault. The Health Canada acts as the secretariat and supports the work of the panel. It's, as required in the legislation, an entirely independent process. I think I can assure you that the panel's report will be available in the month of May. It may be in the latter half of that month. And I can also tell you that the panel and the process is pretty much at its end, in as much as its production and translation and the fine-tuning of the, from a production standpoint of the report that's underway right now. The panel is very conscious of this committee and its work and its anticipated interest in their report. So every effort is being made to make sure that the report will be tabled in a time frame that allows proper and thorough review by the committee. I should just also note, if I may, Madam Chair, that the tabling date is at the discretion of the two ministers, Minister Lametti and Minister Duclos, but they too obviously are aware of the importance of this committee and its review of the report.
Okay, Monsieur Thériault. Thériault, rather.
Thank you. Mrs. Hoffman, last June you were saying that for 2020, the main places where MAID would be administered were private residences, 47%, hospitals, 28%, palliative care, 17%, and long-term care homes, 5.7%. Today, in your testimony, you're indicating that despite the pandemic, that there was an increase of 30% of MAID in 2021, almost 10,000 cases. Do you have the breakdown of the settings where medical assistance in dying was done in 2021?
Madam Chair and Mr. Theriault, no, we do not have that data yet. It will be published in the annual report for 2021, which unfortunately will likely be some few weeks after this committee completes its work. But I would say, based on our observation and reports from the provider community, there is nothing to suggest that the profile of where these procedures has taken place is any different or not certainly any, we're not observing or aware of any significant difference from private years. So I think that distribution that you cited would remain pretty much in place in 2021.
Mr. Thériault, you have...
So despite COVID-19, you could interpret this as there was not necessarily a difference in the practice or the settings. Thank you very much. That's quite interesting. You were saying, Mr. Potter, that with regards to the regulatory framework, there could be, according to the territories or the provinces, extra requirements. Could you give us examples of extra requirements or supplementary requirements that could be requested in some provinces? And how could this affect standardization or access to medical assistance in dying?
Yes, so as I mentioned,
You have 30
provinces
seconds.
for health law very quickly, provinces, as a matter of regulating their health professionals, could, for example, impose requirements about how they are to do the assessment of a patient, for instance, over and above what the criminal law safeguards do. Recall that the criminal law safeguards effectively set a standard minimum floor across the country because a provider can only offer MAID and be exempt from criminal liability if they comply with all the federal requirements. But a province or a regulatory body, as a matter of health law or health practice, could impose additional, more specific requirements that exceed the criminal law floor if that was their intent.
Okay, thank you. And our last speaker in this first round before the senators is Mr. McGregor.
Thank you very much, Madam Chair, for this, and thank you to our witnesses for appearing before our committee and providing an update. You know, when C7 was passed, of course, we're now faced with an impending deadline next year where mental illness as an underlying condition will be removed. And what I wanted to know, Ms. Hoffman, because you did say in your opening remarks that you anticipated the new regime would be difficult for practitioners, and I understand that's in the context of C7 coming into force. But I also think you could use the future tense of that verb in that you anticipate that the new regime coming into effect in March of 2023 will also be quite difficult. And so in the context of mental illness, you know, being in the fact that it will now be considered to be an illness, disease, or disability, and I understand that patients will also have to meet other requirements, that they are in an advanced state of irreversible decline, and that it also causes them enduring psychological suffering. I guess what I want to know from you, given that, you know, Health Canada is working with this deadline in less than a year, what are your conversations like as a department with practitioners? You know, what kind of conversations are going on, and how are they going to develop the guidelines to deal with this very fundamental change to Canadian law?
Thank you, Mr. McGregor, and through you, Madam Chair. Just a couple of comments I could make. One is that I think we have seen this sort of same situation play out in the early days of MAID. I think practitioners at the time were very concerned about their ability, their capacity, and frankly, whether they would have the legal protections they needed if they proceeded with their practice of MAID. So I think we are for sure encountering now more challenging cases where natural death is not reasonably foreseeable, and as you indicated, cases of mental illness. The conversations we've had with practitioners have absolutely pointed to concerns that they have. And there are certainly some practitioners who have indicated that they may not wish to practice MAID in cases other than those where a natural death is reasonably foreseeable. But what we are hearing more often, and particularly from our interaction with providers who are associated with this organization I mentioned, CAMAP, is that they want to have the tools, they want the education, they want the interaction with their colleagues, which will assist them to make the kinds of very complex clinical judgments that have to be made about whether or not a person actually qualifies in terms of the characteristics you enumerated of a grievous and irremediable medical condition. And they also need support to apply the safeguards, particularly those safeguards that have to do with the offer of available supports and services that might alleviate the suffering of a person. What I think we're observing, I will say, and we expect this will continue, is that while the number of providers involved in MAID is increasing, in fact, the increase in the number of cases is being dealt with by fewer people. That is, more MAID practitioners doing more cases. And so what we're seeing is the evolution of a specialty. And hence, that's why support for this accreditation training program is so vital because it is going to require a level of expertise to address all of these sort of standard concerns, which everybody agrees are legitimate concerns about mental illness, for example, incurability and irreversibility, how to assess competence and capacity. What about suicidality? What about other vulnerable circumstances that play into the person's condition and therefore the assessment? So we're hearing, I don't know if I want to call it concern, what we're hearing is the need for support. And the MAID community has, in our view, really stepped up to work to try to address these issues. But it's not to say there will not be some attrition among some providers who have concerns. I mean, I think that is kind of natural and understandable.
There's 30 seconds remaining.
Thank you, Chair. I'll donate that back to the committee so that I've got more time in the next round. Thank you.
Okay, thank you, Mr. McGregor. So we'll go to the senators next. Senator Meiji, followed by Senator Kerr, and each senator will have 3 minutes each. Thank you.
Merci, Madame la Présidente.
Thank you, Madam Chair. My question is for Mrs. Hoffman. In your statement, you said that you will require that information be collected on race, Indigenous identity, handicap situation, but will this allow the... I believe that you were talking about determining what were inequalities in the MAID system in Canada. What do you know about systemic inequality in the MAID system in Canada right now?
Well, I cannot speak with absolute certainty, but the impression that one has talking to providers and looking at some of the data is that, and frankly, some of this is anecdotal data, is that the individuals who seek MAID are generally reasonably well educated. They may be middle class professionals. They are people, and this is a very important point, who appear to have had positive ongoing engagement with the health system. These are not people who are disenfranchised in terms of access to health care. They are people who have had a respectful and positive relationship with healthcare providers. So we don't know, and we think largely they are white. But again, we don't have solid data on that. This is an impression. The data that we will collect will help with some understanding, but that data has to be complemented by other research that actually involves dealing with people, speaking to people who are seeking MAID, better understanding the circumstances that are driving their request, understanding the totality of their circumstances. And we plan to support that type of research. And we're also using the data that we are collecting through the monitoring system to link it to healthcare utilization data, Statistics Canada data that is collected, and data collected and accessible through the Canada Revenue Agency. So we will use and try to assemble all of these sources to have a better sense about access and, frankly, how MAID cases from people in different population groups are delivered, but more importantly, how they are experienced by the people who enter that system or, frankly, who choose not to enter it, because their motivations may be important as well.
Senatrice, there's only about 10 seconds.
Merci pour votre réponse.
Thank you for your answer. I think that it would take 10 seconds to at least understand that you don't have any data at all on the number of Black or racialized people who ask for MAID, if I understood the answer you've just provided.
That is correct at the present time, and that is absolutely something we need to fix. And Bill C7 directed the Minister of Health to develop regulations that would ensure that we would collect that kind of data. So that is what we are doing.
Okay, merci. Senator Kutcher.
Merci.
Thank you. Thank you very much, Madam Chair. And thank you to all the witnesses. And I want to acknowledge your expertise on this incredibly challenging topic. My questions are, I'm going to two questions together for Ms. Hoffman. First, about 15% of Canadians have a mental disorder. What proportion of those receiving MAID currently would have a comorbid mental disorder? And the second one, for those who receive MAID, what proportion would identify psychosocial factors as opposed to physical factors such as pain as the primary reason for requesting MAID?
Thank you, Mr. Kuchar, Senator Kuchar. I can't, maybe one of my colleagues from Health Canada, but I cannot give you off the top of my head an indication of the number of individuals who have a comorbid situation where they have a physical illness and a psychological or mental condition. If one of my colleagues can answer that, I will ask them to do so. But I think at this point, we actually don't really have that data. In terms of psychosocial factors, I would say that when you look at the explanations that are given by persons requesting MAID and documenting by the providers who complete the reports that are required under the monitoring system, and the things they say about what is causing their suffering, and of course, lots of them, if you have terminal cancer and a very short life expectancy, then the physical pain is clearly going to be very high. But when people talk about the fact that they sort of feel they no longer can do the things that they formerly did, that they need more assistance than they feel it is dignified to receive in order to carry out the normal activities of daily living, I would sort of describe that as falling under the psychosocial dimension. I think what we want to get at, particularly in the cases that are starting to come into the MAID system now of people whose death is not reasonably foreseeable, is are those kind of psychosocial circumstances, can they be alleviated in any way through supports? What we generally see with people whose death is imminent is that they are, to be candid, sort of beyond the point where more income support or more social interaction would actually cause them to say, I'm not going to proceed with my MAID request. But we are entering a new world where documenting, and that's why the safeguards are so important, documenting the kinds of support that are offered and then considered by people requesting MAID is going to tell us much more about how psychosocial circumstances and other forms of status in the society play into a person's request for MAID. But we don't see that now as such a critical factor in cases of MAID for people whose death is reasonably foreseeable.
Thank you very much for that. So would it, and certainly what you said makes sense about this other group having, when we need the guidelines and the guardrails and the safeguards, and hopefully we'll get that from the committee's reports. Would it be fair to say that currently, in the current situation, that the majority of people seeking MAID do it primarily for psychosocial factors?
I think it's hard to tease out the difference between the suffering, the pain, the lack of capacity, mobility, difficulties communicating, and all of those kinds of things that may follow, particularly the intense pain associated with a very serious medical condition. Very hard to separate that from the person's anxiety, their sort of existential questioning. When you speak, and I hope you will, to some MAID providers, I think they can probably give you a stronger sense, a more kind of at the bedside, shall we say, sense of what the mentality is of individuals.
Okay, thank you.
Thank you very much.
Thank you, Ms. Hoffman. Senator Delphine, you'll have 4 minutes, and I will make sure I add more to Senator Meiji next round because there are only 4 senators now, and I will have 3 minutes following you. So, Senator Delphine.
Merci, Madame la Co-Présidente.
Thank you. My question is for both witnesses and has to do with policies. There is strong support in Canada for advanced directives. This was recommended by many people, including the Senate. When we're drafting policies, are we looking at a complete system for Are we allowing the interpreter? Sorry, could he move his microphone slightly?
Sorry, Senator Delphine, the interpreter, you're having difficulty hearing, so would you move your microphone up? Merci.
Yes, I'm finished my question. Should I repeat the question?
Senator Delphine.
Thank you, Mr. Co-Chair. So I was saying that my question had to do with advanced requests. Surveys show that there's a strong support for this measure by Canadians, and the Senate recommended this, and the previous joint committee also recommended this. So I was wondering, with regards to policy drafting, if the people with us here today also are looking at a complete system, or would it allow the criminal code to have directives for advance requests and allowing provinces to determine formalities and modalities with regards to directives around advance requests, presence of witnesses, etc. Is this clearly understood?
I can perhaps start with a response to the senator's questions. So the scope of a federal regime for advance requests, if that's the will of Parliament, is one issue this committee should certainly consider. And some of the features, as I mentioned earlier, are: is it desirable for Parliament, or is there interest in putting in frameworks on both of the points in time I mentioned? So the area at the time when the request is made, without federal safeguards or procedures for that period of time, then the practitioner who actually administers MAID, perhaps years later, wouldn't necessarily, there wouldn't necessarily be a guaranteed standard in place for them to know why they can have confidence in the integrity of that request, the information the patient was given, for example, why that request can be said to be truly representative of what their wishes were in the past. And so that's one point in time that is, as I mentioned, more typically dealt with as a matter of health law, but where Parliament may wish to give consideration if there's a desire for standardization. Otherwise, there is a possibility that if provinces do not occupy the field, then there could be variance across Canada in how advanced requests are created, how they're stored, how they're documented, and then how they would ultimately be used. But I think we would all agree that having that second practitioner who's going to administer MAID be very confident in that original request is an important consideration to ensuring that it's voluntary. And so I think you're right to point to the issues of how that gets constructed is certainly a very important issue.
Ms. Hoffman?
I will only add to what Mr. Potter has said, that even today, when it comes to advanced directives, which are kind of much less, in many cases, significant in their consequences, but they are mainly distinguished from an advance request because they are only about the withdrawal of treatment, that the systems within provinces and territories, within institutions, and across the country are not only diverse, but they are frankly not all that functional. And so a request that may be made or a directive that a person may file in the context of their interaction with a family physician or a visit to a hospital or whatever may or may not actually surface again on some future occasion. So there would be an enormous amount of work to be done, not just at the level of the legislation and the permissibility of such a regime in the criminal code, but in the actual implementation within the healthcare system. So this is not offering an opinion about whether or not advanced requests should be permitted. I'm just commenting on the infrastructure that would be needed, and including, for example, periodic renewal of the request, so that any last request that is made is as proximal as possible to the point in time when the person has identified as when they would like that advanced request to be actioned.
Thank you. Thank you, Ms. Hoffman. Thank you, Senator Dalphon. Next, we'll turn to Senator Martin for 4 minutes. Go ahead, Senator Martin.
Thank you, Mr. Co-Chair. This is a question for Abby Hoffman. You mentioned that the federal government was funding some training for MAID providers. Now, health is provincially directed, and whether it's training or whatnot, it would be done at the provincial level. So I'm just wondering what you meant by is it with specific provinces? We know that there's different advancements of the MAID practice depending on the province. So if you could clarify the role of the federal government in doing such funding.
Sure. And, this is not kind of untypical of the sorts of things that the federal government takes on, whether it's in large quantities of money through the Canada Health Transfer or smaller projects. Obviously, the federal government plays a role in various aspects of healthcare. So specifically what we're speaking about here is that there was the creation, it emanated from the practice community of MAID that led to the creation of this Canadian Association of MAID Assessors and Providers. They were the ones, through the interaction with their communities, who said, we need to regularize practice. A good way to do that is through an accredited training program. And I will also note that across the board in the healthcare system, specialist training is accredited by the Royal College of Physicians and Surgeons. So the expectation here is that MAID training would be accredited through that same system. It would be up to individual provinces and territories to decide whether or not they wanted MAID providers in their jurisdiction to make it mandatory that this training and this accreditation be something that a provider would have to have in order to practice MAID in that province. So a lot of these things do work through collaboration between national bodies and provincial bodies, and the provincial regulatory bodies for physicians and nurse practitioners. They too would be part of this discussion. But this is a normal kind of
okay. Thank you.
approach.
And naturally, there will be differences, and I'm concerned about those challenges that are faced between rural and urban providers. And so, who is addressing these sort of differences in how things are administered? How will we achieve that kind of consistency?
Well, in some provinces, quite a few actually, there are what are called MAID coordination networks, so that somebody, regardless of where they live, actually enters the system through this coordination network. And then the resources that are needed are, I'm not talking about the financial resources, it's mainly the human and professional resources, are allocated to the individual in question. As far as the training is concerned, it will be delivered both online and in person. So hopefully that will help with providers from smaller communities. But look, I'm not going to misrepresent the situation. In the new cases of access to MAID for people whose death is not reasonably foreseeable, it is a much more complex assessment process. There needs to be an expert in the person's condition if one of the two assessors or providers does not have that information. This is very challenging, and a lot of efforts are going to have to be made to make sure that access is equitable for people who are living in smaller communities, because it is a much more complex process.
Right, and I'll ask again in my second round as to the complexity of that. Thank you. Thank you, Mr. Barrett. And we're going to go into the second round for the House members. So we'll begin with Mr. Barrett for 3 minutes, followed by Dr. Fry for 3 minutes. Mr. Barrett.
Thank you, Madam Co-Chair. My first question is, I'm looking to see if the government acknowledges the contention made by the World Health Organization, as well as that by the Canadian Hospice and Palliative Care Association and the Canadian Society of Palliative Care Physicians, that MAID and palliative care are separate and distinct practices.
Well, I would say that the actions of the palliative care community would suggest that they are not completely separate and distinct. I think it was perhaps Senator Kuchar or one of the other members who spoke who mentioned that significant number of MAID procedures actually take place in palliative care units. And when it comes to the providers who are involved in MAID processes, there is a significant proportion of those providers who actually are physicians with a palliative care specialist. And I think it was the case in the early days of MAID and in the lead up to the original framework in the criminal code, that there was a bit of a standoff between the palliative care community and palliative care providers and the MAID community. But I think over time, there has been an inclination to look at end-of-life care in all of its facets and components, and for many palliative care providers to see that MAID is not a testament to the failure of palliative care. I mean, it is a reality that sometimes palliative care will not relieve an individual's suffering. So we don't see this kind of antagonism, shall we say, between MAID and palliative care.
Thank you, Ms. Hoffman. The two leading Canadian palliative care associations have called for, quote, prioritization of, adequate investment in, and enhancement of palliative care services as a separate service from MAID, close quote. How has the government of Canada responded to these calls and requests?
I'll start with a response to that. First of all, although we have provided to the provinces some very significant amounts of money through the recent health accords for home and community care, including palliative care, we cannot and we do not direct provinces in terms of exactly what they should do and how much of their resources they should direct to palliative care. But we know that they are making improvements, and we also know that the palliative care system is not as strong as it should be. If you are a person who is suffering grievously with cancer, the continuity of care system that works in the cancer world will likely ensure that you get access to the palliative care that you need. But in the case of many other diseases, that may not be the case at all. The other thing that
thank you, Ms. Hoffman. I apologize. We're past 3 minutes, so we'll go to Dr. Fay next.
Thank you very much, chairs, and thank you again to Ms. Hoffman and Mr. Potter for coming on and sharing the information with us. I must say that I'm impressed by Ms. Hoffman's ability to answer these questions that are very complex with her own complex knowledge of the issues itself. So she's been really following up on everything. I have two quick things I want to ask about. One of them has to go back to the issue of advance directives. Now, before MAID and before the Carter decision, et cetera, physicians have been providing advance directives with their patients for ages. They've been doing it under the guideline of the colleges to talk about an ethical decision making with a patient who feels that they want to have advance directives. And it's been done under those jurisdictions. So I want to know why, and is there an intent for the government of Canada to decide that they will enter into the College of Physicians and Surgeons ethical and knowledgeable decision-making by which they guide physicians and suddenly impose some sort of heavy-handed legislation on how physicians should practice with regard to things like advance directives, which are very, very physician-patient related and therefore privileged decision-making. First question. Second question, just before, and then I'll let you guys go after it. The second question is, we know that the question of vulnerabilities, social vulnerabilities and other vulnerabilities, we know that there are many countries right now that have had long-standing practice of MAID. Luxembourg, Belgium, Switzerland, Washington, Oregon State, etc. And we know that, in fact, two stand out, the Netherlands and Oregon, with regard to looking at the issue of how to protect vulnerable persons in how MAID is done. And they've now have good evidence-based decision on how that worked and whether it looked or not. Have you guys been looking at those jurisdictions for what their evidence is now telling us? Thank you.
There's only 1 minute remaining, so Mr. Potter or Mr. Potter first, and then you'll have to both be very brief. Or Ms.
I might just very briefly on the first question. Thank you, Madam Chair. Just note that advance directives and MAID are very different things, and that advance directives as they currently exist are for refusal of care, which somebody has always had a right to do, whereas MAID legally is an act that requires a criminal exemption because it actively ends a person's life. So there is an important distinction there, at least from a legal perspective, and I'll let my colleague Ms. Hoffman add on.
Okay,
Madam Chair,
30 seconds.
we'll have to come back to these issues because they're very important ones that Dr. Fry has raised. On vulnerability, maybe just 2 quick points. One is the new safeguards for cases where people are not dying do try to ensure that the provider gets at the totality of the person's circumstances and make sure that anything that could relieve those features of the person's vulnerability beyond their medical condition, that there's an opportunity to address those. I think the one thing I just want to say is that vulnerability in the experience with these other countries and the plan in Canada would be that it has to be assessed in the context of each person. We cannot say that because someone is a member of a group, therefore they are vulnerable, therefore they cannot get MAID. That is absolutely
Thank you. And we will return to this hopefully at the next round. Okay, we actually go back to the 5-minute time slots, and questioner will be Mr. Barrett, actually. Or did you want to go back to Mr. Cooper? It's a 5-minute round.
Mr. Barrett? Madam Vienne, I thought. I'm prepared to go, but I thought it was Madam Vienne.
Yes, that's correct.
She will. Okay, thank you very much.
Thank you.
Okay, Madam Vienne.
Merci beaucoup et bonjour.
Thank you. Thank you for our guests for being here. My first question, Mrs. Hoffman. When I look at the presentation that you made earlier today, and perhaps I misunderstood, and you can tell me if I did, you seem to indicate that in the 2020 data, the proportion of the death, you said it would stabilize around 4%, and MAID procedures as a proportion of all deaths. So how do you determine that it's 4%, and how can you say that MAID procedures will stabilize at 4% when we know that there will be more openness to different situations, notably with regards to mental health situations? So how did you arrive at this 4% number? And given the situation that will evolve, how do you arrive at this proportion of all deaths at 4%?
The reason we're saying that is we're just 2 things. One, we're looking at other what we'll call progressive regimes of MAID in other countries. So the Netherlands, as an example, and over time there was growth. It eventually reached the point of approximately 4% of all deaths, and we think that that is likely in Canada. But there's no more science to it than that kind of international comparability. I think the other thing that, and look, we will have to see how this plays out. I mentioned that there were 200 MAID deaths associated with people whose death was not reasonably foreseeable. So this is a small number, but understandably in the first year after the new legislation. We'll see, but we are not anticipating right now that there will be vast numbers of people whose natural death is not foreseeable, who will be seeking a MAID death, or people whose principal underlying condition is a mental illness. I mean, we may be proven wrong, but that is what we see at the present time. And I'll just say we know the rates in some parts of the country are higher. In Quebec, for example, on Vancouver Island. Whether that will be the case across the country remains to be seen. It's a combination of the will of individuals and the receptivity and preparedness of the health system. Both need to be in place to influence the rate of MAID procedures.
Madame Hoffman, vous m'ouvrez la porte.
Mrs. Hoffman, perhaps you raised this earlier, but you said to my colleague, Mr. Theriault, and this is what you said, that there was a 30% increase of use of MAID. And so this seems significant. So I understand that what you're observing throughout the country is variable, This increase of 30% throughout the country is important. It's a very large number, but it varies depending on the region of the country. So what is your reading of this according to different provinces?
Well, I think some of you may have observed this, but I'll just note, for example, that there was recently some television coverage of access to MAID on Vancouver Island. And one of the things that the physician who is in charge of MAID services in that part of the country said is that they are open and they help ensure that every healthcare institution on Vancouver Island knows about and is prepared to accept and to deal with MAID requests. That is not the situation everywhere. Attitudes are different in different parts of the country. The rates in those parts of the country that were less inclined, whose citizens were less inclined to pursue MAID, are starting to increase. Look, I don't want to be held to this 4%. I will just note that there are differences, and some of those differences will persist, but 4% is a kind of number in a system where MAID can be both provided by a practitioner as well as self-administered. In those societies where MAID is, and it is the case in Canada, almost all of the cases are actually administered by a provider, not by the individual who wishes to see their life come to an end. This approximate 4% is in place. What we hope is that there will not be institutional or other barriers so that someone, for example, who's living in a long-term care or is living out their life in a hospice and is told, sorry, you cannot have access to MAID in this institution. That is a barrier we're concerned about.
Madam Co-Chair?
Yes.
So just on procedure, I just would like clarification on the round that just concluded. So we had 3 minutes for the Conservatives, 3 minutes for the Liberals. Should there have been time allotted in 2-minute increments for both
to the Bloc and NDP? Yes, I'm doing that next, and then we will Oh, you're saying that I skipped them by mistake. You're right, Mr. Coop.
Yeah. So just 2 minutes for the Bloc. So we would need to go back and do 2 minutes for Mr. Theriault, 2 minutes for Mr. McGregor, and then go back to the Liberals.
Yes, and I apologize. I have all of this listed in front of me, but my eyes have made play tricks. Thank you for that, Mr. Barrett. So there, in the round 2, there should have been 2 minutes for the Bloc speaker and 2 minutes for NDP. So I will return to that and then come back to this 5-minute slots. So Mr. Theriault for 2 minutes, followed by Mr. McGregor, and apologies.
I thank my colleague, Mr. Barrett, for raising this. So we're looking forward to reading the experts' report with regards to mental health, illnesses, and different conditions. But right now, there are some things that you can tell us to help us to navigate this. There are some jurisdictions that proceed with MAID in cases of people with a mental health disorder. Could you speak to protection measures in place in these jurisdictions? And also tell us right now, today, what are the lessons that could be learned from these experiences? I understand that they are few and far between, but what would be lessons learned? It doesn't matter which of the witnesses speaks.
I might begin and just say that one difference that's significant between, say, Belgium and the Netherlands and Canada in terms of our MAID frameworks is that Belgium and the Netherlands have a criterion that effectively requires the other treatments or alternative means of alleviating the suffering to have been tried and failed, whereas in the Canadian MAID legal framework, it's for the individual, the person seeking MAID, to determine whether any particular treatment is is acceptable to them or not as a means of alleviating suffering. So that's one important difference between the regimes that you might look at. And just as a more broader comment on lessons learned, it's while those jurisdictions certainly do have a longer experience with MAID outside of a very end of life context compared to Canada, these cases remain controversial and difficult, even over there. And so it's one of those things too where there are important differences not just in the legal framework but also in our health system and in our society that the committee may wish to consider as well in looking at this issue. Just the geography of Canada, the shared responsibility between the provinces and territories, etc.
Just very quickly, Madam Chair, if I could add, just apropos of.
Sorry. These are 2-minute slots, so I'm assuming that we can continue with some of these answers after, but we have Mr. McGregor scheduled next for 2 minutes.
Thank you, Co-Chair.
Mr. McGregor?
Thank you, Co-Chair. Mr. Potter, you have clearly illustrated the challenges that are before us if Parliament decides to approve advanced directives for medical assistance in dying. The practitioner is going to have confidence that the directive was done in a sound manner. There could be an incredible length of time that has passed between when the directive was first made to when MAID is administered. It could have been made in a different provincial jurisdiction, et cetera. I guess my specific question to you, because my time is limited, is, what kind of challenges specifically do you see the criminal law having with an evolved understanding of diseases? Because, of course, our medical understanding of living with various mental illnesses has evolved over the decades. And how do you think the criminal code could appropriately take that into account, our evolved understanding of, maybe 10, 20, 30 years from now, there may be different ways of helping people cope through various mental illnesses, which under a current regime may qualify them for medical assistance in dying. How would an advanced directive take that into account through the criminal code, or is that something the provinces are more going to have to take into account?
I mean, at a very high level, what I would offer you is that the way the provisions of the code are designed is that they're sort of condition agnostic, so to speak. They don't focus on particular medical disorders or one disease or the other. But part of the safeguard regimes, like if you look at what C7 added, for example, that a person be offered consultations and have given serious consideration to other means of alleviating suffering, like that type of language in a safeguard can evolve as treatment options evolve and as our understanding of illnesses evolve. Because what might be a treatment option in 2022, maybe we have more treatment options in 2042, for instance. So the way the safeguards are drafted in the current code are able to evolve with the times, but you may wish to, if you're thinking about safeguards more generally or for anything, it's an important feature to bear in mind that you may not want something that only addresses one particular type of condition, because then that may be difficult to apply across a broader range of circumstances.
Okay, thank you, Mr. Potter. And we'll return to the next person with the 5 minutes. It will be Mino, followed by Mr. Thériault.
Who was it, Madam Chair? Mr. Arsenault.
The next speaker is Mr. Arsenault.
Merci, Madame la Coprésidente.
Thank you, Madam Co-Chair. So the best questions and the most interesting questions have already been asked. Mrs. Hoffman and Mr. Potter and your entire team, I salute you and congratulate you for the solidity of your testimony and your solid knowledge of the subject. I would like to ask you, before you finish the study, are there some data that could be made public and that we don't yet have knowledge of? Please send this to our clerks so that we can be apprised of this if it happens before the end of our study. What interests me particularly today, if we look at palliative care with regards to requests for MAID and statistics and the data that you've presented with regards to MAID, you said that MAID had been requested and that patients had not necessarily gone through palliative care. Could you backtrack a little bit and give us some statistics? I thought I understood that it was 17% of people in palliative care that had made the request, and the rest came from people who were not patients in palliative care. Did I understand this correctly?
Mr. Arsenault, if I may, just I think, and I apologize if what I said was a bit confusing. A couple of points. First of all, the overwhelming majority of individuals who make a request for MAID and who receive MAID have had palliative care. Not just access to palliative care, they've had palliative care, over 80%. Of the remaining who have not had palliative care, the overwhelming majority of them had access to palliative care if they had wished to pursue it, but for whatever reason they didn't, likely because of the kind of very close to the end of their life situation that they're in, because we are now talking about data that pertains to people whose natural death is reasonably foreseeable. The 17% that I referred to was the number of the proportion of MAID practitioners who are palliative care physicians. And I was just making that point in the context of the relationship between palliative care and the practice of MAID, and noting that there is now agreement among a substantial portion of the palliative care community that MAID is a legitimate practice that should be offered to people and responded to when a person requests it. Now, having said all that, I'm not going to say that palliative care in Canada is perfect, and that every person who has palliative care gets the amount and the duration of palliative care that they need. There are still many issues in terms of access to palliative care for people who are living in their own homes, who do not need to be hospitalized, or who are living in other institutional settings other than a hospital. Those are still big gaps that need to be filled. But I hope that clarifies the
Oui, oui,
that
merci. Merci beaucoup, ça clarifie.
Yes, thank you. That clears up a lot of things. I understood something different. Through this data, when we talk about palliative care, as you're saying, Mrs. Hoffman, can be people at home with mobile units of nurses who provide assistance and palliative care, or people who are in private palliative care institutions, and it can be people who are at end of life on a palliative care floor in the hospital. Do we have data with regards to these three different types of options?
Yes, we do. I cannot cite it just off the top of my head, but there was a very, I think, robust study done by the Canadian Institute of Health Information that was published in 2018, and I'm happy to provide that to the committee. And it was very clear that depending on the disease, particularly chronic obstructive pulmonary disease and cancer, high probability of getting access to palliative care. If you are in a hospital, yes, higher prospect. If you're in a home situation, lesser prospect. And it's very clear also that one of the things that we need to do is to move the delivery of palliative care from exclusively palliative care specialists to people like paramedics who can, and there are programs that do this, delivering palliative care in people's homes, training family physicians so that they can be interlocutors for palliative care services as well.
S'il vous plaît,
Please, could you send us this data if we have not yet received it? I have 20 seconds left. Last question. Do you see a disparity in the MAID services according to rural, to urban regions, or the north of Canada, or according to different provinces?
According to our data, no, but I think in reality, and particularly with the more complex cases that will arise under the new MAID legislation, I think this is something we really need to pay attention to, or there will be disparities because of the complexity of the assessment process.
Merci beaucoup.
Thank you. I will call on Mr. Thériault next for 5 minutes, followed by Mr. McGregor for 5 minutes. Mr. Thériault.
First of all, I will allow Mrs. Hoffman to complete her answer that she was providing to me earlier.
Thank you, Chair and Mr. Thériault. What I was wanting to comment on was in response to your comment in question about what might we learn from other countries with respect to the practice of MAID, especially in cases of mental illness. Now, look, I'm reticent to comment too fully because you will hear from the expert panel later on in your process. But two things I will say. One is that most of the guidance that is required is at the clinical level. It's direction to practitioners about what they should do to deal with these very complex challenges that are associated with these cases. This is not, with all due respect to my colleague, Mr. Potter and Joanne Kleinberg, who are on this call, you cannot put detailed clinical guidance in the criminal code. It's not the right place for it, because as Mr. McGregor indicated, the understanding of diseases and conditions and their trajectory and treatments and so on evolves. The second thing I would say is that the human resource requirement will be very significant and intensive if a proper assessment, and that is the only assessment that should be allowed, but if a proper assessment of whether or not a condition is incurable, whether or not the decline that may be associated with that disease can be reversed or attenuated or relieved in some way, whether or not the person has capacity, do they understand what it is that they're being told about their condition? Do they understand what it is that they are doing if they are seemingly making a request for MAID? All of these informed consent, capacity, irremediability issues are incredibly complex, and they will take a lot of time. And as with other cases where the person is not dying, in order to understand whether or not treatments and interventions are effective, you have to reflect back on all of the experiences that person has already had with the health system. What have treatments yielded so far? So the bottom line here is that those cases will be very demanding, and the human resources will have to be intensively applied. So that I would say is probably the paramount lesson that I would put in front of the committee for your consideration.
C'est probablement pour cette raison que
That's probably why, when we look at the report to revise the Act in Quebec, people decided not to go ahead with this issue. And so when we read advice with regards to MAID, when there is only a mental health ailment, there's no consensus. People seem quite divided on this issue. So I'm looking forward to see what our expert group is going to recommend.
If I may, Madam Chair, that there's never been absolute consensus on any aspect of MAID. I think the question is there a safe and reasonable way for cases to proceed? That's really, I think, the fundamental question.
Oui, toutefois.
Yes. However, on many aspects of MAID, even if there was no consensus, we did not have the impression that it was almost 50-50, the divide. But when we read all the reports, it seems as if one person out of two will have an opinion, an opposite opinion. Is quite divided. So on this issue of mature minors, there are very few countries that practice. We're talking about Netherlands and Belgium, and they authorize mature minors at 12 years of age and over, but parental consent is necessary for children between 12 or adolescents between 12 and 16. And is there one process made for mature minors that does not require parental consent? I have not seen any up until now. It seems to be intrinsically linked. There is a process, and the parents do participate in the process, it seems.
même s'il y a
Okay,
très peu
we're
de
at
temps.
5 minutes, Ms. Hoffman. So I think you'll have to answer this in Mr. Tergio's next 2-minute round. So if I can pause here. Colleagues, I have to pause to tell you about an additional witness that is available. And with your consent, we could hear from this third witness. She's been already tested through all of the technicians on this call so that she'll be able to provide her testimony. It's Mosumi Banerjee, Director, Office for Disability Issues from ESDC, Directrice, so I don't need to translate, but Mosumi Banerjee has been already tested for sound. So is there agreement to hear from this third witness before we go to the senators round, where each senator will receive 4 minutes and I will take 3? Is there consent or agreement? Okay, merci. So we'll invite our third witness to add to this very depth and complex conversation that or dialogue that we are having at this committee. So is our third witness ready to join and present? Yes, merci. Bienvenue, thank you.
Thank you, Madam Chair. Would you like me to speak now?
Yes, please.
Okay. Hi, I'll introduce myself again. I'm Mosumi Banerjee, the Director in the Office for Disability Issues in ESDC. My team works very closely with Health Canada to support them on MAID issues and the regulations that are being developed. Our main role in this work is to provide a disability inclusion lens to the work that is being done to ensure that organizations representing persons with disabilities are being engaged. We help with, the types of questions that are being asked, and we connect Health Canada with organizations and individuals that we think should be engaged with, and provide support in that way, as well as to our minister to provide her with briefings to be able to engage with the Minister of Health. I don't have any other further remarks because our role is very much a support role and a disability inclusion lens role, but I'm available if there are questions. Thank you very much.
Thank you very much. Now we will go to our senators round, and I'll ask
point of order.
Yes.
Senator Martin, I believe I have 5 minutes following Mr. Theriault.
Oh, I apologize. I thought I had completed that round. So yes, Mr. McGregor, you will have 5 minutes time.
Thank you very much. My question is to Ms. Hoffman, and it's again on the subject of mental illness. We know that the guidelines are like the amendment that's coming into force soon will come into force next year. Actually, I'm going to switch my question because we've got Ms. Banerjee here. My question to you is, on the subject of persons with disabilities, do you have information to share with the committee on the population in Canada that is currently living below the poverty line?
I actually don't have it on the top of my head, but I can send that information. That is information that we do have, and I could find that information.
Okay, that would be appreciated if you could provide a submission to the committee, a brief to the committee in written form.
Sure.
Thank you. Ms. Hoffman, maybe I'll turn to you, and actually I'm going to switch it up to stay again on the subject of advanced directives on medical assistance in dying. We know that there has been a 2021 report on the dementia strategy for Canada, and a lot of that report did also touch on the stigma associated with people living with dementia. I guess my question to you from Health Canada's perspective, because this is really going to be a central facet to Parliament's discussion on advanced directives, is our understanding of people who are living with dementia. How is our understanding evolving in that respect? And what are we learning in this day and age of people who are living with dementia, the stigma associated with it, the strategies that are now coming into place to assist people living with this disease?
Thank you, Mr. McGregor. Look, I'm not an expert on dementia or specific neurodegenerative diseases writ large. I think that I could make a couple of general comments nonetheless. I think that the discussion about dementia and associated illnesses that have similar symptoms and manifestations is very helpful in reducing stigma. I mean, one can imagine now more acceptability of people with dementia for a significant portion of the time when they are living with that disease, being able to live in the community, having some sorts of interaction, et cetera, outside of an institutional context. So I think the situation is changing, and I think without overstating how quickly that sort of stigma reduction, or for that matter, the capacity for families to actually maintain in their own home support for a person living with dementia. I mean, I think it's still the case that there comes a point when that is extremely challenging and unfortunately very impractical, even with the best supports in the world.
Thank you. And I just want to sneak in a quick question on the mental health aspect. The last 2 years of the pandemic have brought about a rise in mental health in Canada, the number of cases that we're identifying. I guess what I want to know is, when a mental health condition becomes a basis for getting medical assistance in dying, with the understanding that they have to be in an advanced state of irreversible decline, and that has to cause enduring psychological suffering. My question to you is, what strategies is Health Canada putting in place to ensure that people who have mental health issues, that they are not advancing to a state where it meets those conditions? Like what kind of strategies can you inform the committee that we're putting into place? Do we have adequate funding? Is this something that we need to address more in Canadian society?
Well, I think despite actions, whether it's a mental health transfer to provinces or other specific initiatives, I mean, the reality is we read it in the papers all the time. We probably all know friends and neighbors and other families who are dealing with these challenges, that the supply of mental health services, particularly for people with, I would say, lower acute conditions that may, as you're suggesting, deteriorate further in the absence of care, that there is a problem of adequacy and sufficiency of intervention services. So that is something that I think all governments are working on. But as you have noted, through the pandemic, it's become evident that particularly, but not only, but particularly among young people, there is kind of a pandemic of maybe it's COVID-related mental illness, or maybe it's just coming to the fore.
Okay, thank you, Ms. Hoffman. That's 5 minutes at this time.
Thank you.
I need to also ask the committee. Earlier on, we had a point of order from Mr. Ananda Sangari regarding having 15 minutes for us to meet in camera. So if you're in agreement with that point of order, the clerks will prepare a new link that will be given to us for the last 15 minutes. And I know that we will have our witnesses until 5 p.m. So until then, we'll continue with our order of speakers. So I'm going to turn this over to Mr. First of all, before we do that, do we have an agreement for that? Yes.
Point of order, Madam Chair. I don't believe the request included that it be held in camera. I think it was simply that we use the last 15 minutes to discuss some issues. This would save time, because if we have to click off, click on, we're going to lose another 10 minutes. Makes a big difference.
I see. And Mr. Ananda Sangari, was that your request then?
That's
just
correct.
To use the last 15 minutes?
That's correct, Madam Chair.
Okay, all right, that's fine then.
I did not request.
Okay, I misunderstood.
Thank you.
All right, thank you for that clarification. Okay, I will turn this over to my co-chair, Mr. Barrett, for the questioning of senators, questions from senators.
Thank you, Madam Co-Chair. Next to Senator Meiji for 4 minutes. Senator. Senator Meiji.
Oui, bonjour, monsieur.
Yes, hello. Can you hear me? Can you hear me? Yes. Great. Still, for Mrs. Hoffman, I would like to come back on the regulation that would allow the collection of detailed data on people that are living with a handicap or racialized people. Is this being prepared? And if yes, when will this be ready? And how will the data collected, how will this allow the government, how will this inform the government for future political decisions with regards to MAID?
Thank you, Senator. I can respond to that question. The regulations are being written now. They will, we expect, within the next 6 weeks, be published in what's called Canada Gazette 1. So the regulations will be in place. There'll be a further consultation period. The final regulations we expect will be published in the fall. And that means that they will take effect on January 1st, 2023. Now, this may seem like a long time. What that means is that for all of the calendar year 2023, we will have this considerably more detailed data. But that also means that that data will not be available until the end of the first 6 months of 2024. How will the data help? And this will depend also on what requesters for MAID are prepared to disclose, which may not be, they may choose not to disclose this data. But as I mentioned before, we will use this data in conjunction with other research and linkages to other data to try to understand better how the kind of intersection of different forms of inequality may be manifested in the MAID system.
Okay. Merci beaucoup.
Thank you.
You still have just about 2 minutes left, Senator.
Ah, okay.
Okay. I did have another question. It has to do with budgets for palliative care. This is something different, and we've already discussed the fact that perhaps it's a lack of palliative care that makes it so that people are asking for a MAID. We realized no, that's not the case. And then we saw that the data, as you were saying, 80% of people who asked for a MAID had access to palliative care. When it says a person has received palliative care on a form, we don't really know what level of palliative care. Was it 3 days of palliative care? Or has this person been in palliative care for a lengthy period of time? In the forms that can you see if people have received true palliative care on the forms that are filled out by MAID practitioners?
Ça dépend.
Senator,
30 seconds.
The implication of your question is correct. I mean, we have information about whether the individual has had palliative care, but the extent of that care is not well documented. And look, it is the case in many parts of the country, most parts of the country, in fact, that there are time limits on palliative care, the amount of care that one can get, the proximity one has to be to an anticipated death, and so on. So in as much as this committee is looking at the state of palliative care in Canada in general, lots of positive developments have happened, but it still remains 1% of specialists are palliative care specialists. That's a very small number. And resources are at this point growing, but not sufficient to meet what should be the legitimate demand. I think that
Thank you, Ms.
those are
Hoffman.
fair conclusions.
Next, for 4 minutes, Senator Kutcher, please.
Thank you very much, Mr. Chair. At first, is just a clarification from Ms. Hoffman and then a question for Ms. Banerjee. So to date, there has not been a nationally accredited program for MAID providers. I just make sure I understand this.
That's correct.
But since the development of C7, there is currently an accredited training program under development. And the purpose of this is to enhance the quality and standardization of MAID assessment and delivery. And my understanding is that the accreditation will be by the most responsible national medical organizations, such as the Royal College of Physicians and Surgeons. And so thus, it will become a national standard, and which is similar to how all medical practitioners are currently accredited. So if you're a psychiatrist or a gastroenterologist or a palliative care specialist, it's the same kind of level of accreditation. This is not the purview of provinces and territories to accredit. It's a purview of the national medical organizations to accredit, like they do for all specialists. Regulatory bodies, such as colleges of physicians and surgeons in provinces and territories, can at their discretion, should they choose to do so, require that MAID practitioners be accredited. Is that correct?
That is very well expressed, Senator Kutcher, yes.
All right, thank you. Maybe the record can show that. The question is for Ms. Banerjee. What proportion of individuals who have received MAID to date in Canada have had MAID provided solely on the basis of a disability? And if you don't have that data at your fingertips, could you find that out for us, please? And could you also find out in other jurisdictions, such as the Benelux countries and in Switzerland, Washington and Oregon state, what those proportions would be? So the number of people or proportion of people who have solely a disability are receiving MAID.
I will definitely follow up on that question as well to see what numbers we have available.
Great. Thank you very much for that. It'd be very appreciated. I will cede the rest of my time to my colleague, Pierre Delphont, who is much more erudite and astute than I am.
Well, thank you, Senator Kutcher, and we'll move to Senator Delphont for 4 minutes, please.
Thank you. Thank you, Stan. My question is for Mrs. Hoffman. You referred to the fact that the health department report on the year 2021 would be released only after we have reported, because we have a deadline which is coming this June. Is it possible for the department to send off a kind of draft or an outline of what the report will be, or some data, rough data that have not been processed, in order for the committee to get access to this kind of critical information?
Senator, we'll see what we can do. Just as I spoke last year about the 2020 data before it was published, we'll see what we can provide you with. We just want to be sure that we are not providing you with data that has not been properly and fully verified, so that you ultimately may include some data that's not correct. But we will be happy to work with the committee to respond to your very reasonable request.
I assume that 95% of the report would be accurate, so you can have a big caveat on the first page, and we will rely on the 95%. So my next question, really, c'est, je vais parler en français. L'Assemblée nationale.
The National Assembly brought an amendment with regards to providing healthcare services and to not allow MAID for those who suffer from a mental health condition, following the report that was... Could somebody ask Mr. Delphont to lower his microphone, please?
Excuse me, Senator Delphont. I've just stopped the time there. If you could lower the boom on your microphone, please, just for the interpreters.
Where is it?
It's up high, sir.
Oh, sorry.
Okay.
Thank you.
Just that last intervention, and I'll restart, and I'll continue your time.
Merci.
Thank you.
En décembre 2021.
In December 2021, a special committee of the National Assembly of Quebec recommended that MAID not be made accessible to those who had only mental health disorder, that was their only condition. I know that this is a subject that the committee will have to decide on, and we're awaiting the report of the expert committee. If we were to open up access to MAID to people with mental health disorders, how would you see the work with the provinces? Without the collaboration of the provinces, it would be very difficult to go ahead.
Well, that's absolutely right. I mean, look, a province could decide that they wish to proceed with a regime that is more restrictive than that of the federal government. Depending on what the nature of that more restrictive regime is, that jurisdiction could be subject to legal challenge. And I don't want to say that this is akin to the case of Truchon and Gladue, because that challenged both the regime in Quebec as well as that of Canada. But that risk certainly is there. I think on the more positive side, shall we say, we have been and we will continue to be, and when the report of the expert panel is out, there will be extensive discussions with provinces and territories, as well as conversations going on among the clinician organizations about how best to implement the recommendations that we expect the panel will make, and that you will see as part of your work.
Merci.
Thank you.
Okay, thank you, Senator. We'll go to Senator Martin for 3 minutes, please.
Thank you, Mr. Co-Chair. My question is also, again, for Ms. It's regarding the Indigenous communities in Canada, and one of the most compelling witnesses we had at the Senate was a leader of the Dene Nation who spoke about the word suicide not even being in their language. He said not for a very long time, 300 years, which gives us the perspective from which he comes. But my question is, what consultations, if any, are being done ahead of the MAID being open to those who suffer from mental disorder as a sole underlying medical condition with the Indigenous communities?
Yeah, so perhaps I can respond to that. I think that it's probably makes sense to start by acknowledging that there has not been the consultations that are required with Indigenous communities, and I am not referring to Indigenous people kind of as one single population block. Obviously, the distinctions-based approach that's now conventional needs to be pursued in this particular case. We are in Health Canada now in the process of working with representatives and stakeholders in Indigenous communities to try to work with them to figure out what sorts of consultation activities would make sense. This may pertain to the recommendations that come from the panel on MAID and mental illness, but they also apply much more generally to MAID in Canada. And so just as an example, thinking about the training and accreditation program for MAID providers that I've mentioned a couple of times that's being managed and supported by us, that will be very important that there is dialogue with representatives of Indigenous communities about how any of those modules that are being developed needs to incorporate a cultural safety and awareness dimension, so that any practitioners, whether they are Indigenous practitioners or non-Indigenous practitioners, can proceed with the appropriate sensitivity and awareness of concerns from the Indigenous community. But I will also say we need to bear in mind, and we've heard this many times, even on groups where there is significant Indigenous representation, that no single Indigenous person can speak for the entirety of their community, and certainly not for all Indigenous people. So the question is, how can people be sensitized so that they are aware of the kinds of consideration that should be introduced into a conversation about MAID or the practice of MAID where Indigenous people are involved. So that is a process we're engaged in right now, and we will support whatever process the Indigenous spokesperson say they want to pursue. If they want to have us involved,
Thank you,
we will
ma'am.
be. If they don't, we will not. Thank you.
Thank you, ma'am. That's your time, Senator.
Okay, in fact, in round two, second round, Mr. Barrett, it's your turn to have 3 minutes.
Thank you, Madam Co-Chair. So palliative care must be made available to any patient who's thinking about MAID. It needs to be a safeguard for folks who feel like they don't have any other option. Through the testimony today, we hear that there's a significant number of people who are only able to discuss palliative care on the day of their MAID request or after their request was made. And this is in addition to the gaps that have been identified across the country in palliative care. When people aren't offered proper palliative care, or they're not afforded time for consideration or to make an informed decision before their request for MAID, does this not point to a systemic non-compliance with MAID safeguards?
If the question is addressed to me, Mr. Baird, I'll try to respond. I don't think this is a systemic disregard for the legislation. What the legislation says is that someone can only give informed consent to receive medical assistance in dying after they've been informed of the means that are available to relieve their suffering, including palliative care. That is the requirement. There's no specific requirement that says when that palliative care service should have been offered to the person. I mean, look, MAID is not set up to address every perceived or, for that matter, real deficiency in healthcare service delivery in Canada. It could not possibly take on that role. Palliative care has been given an important and prominent place in the original MAID legislation and in the new legislation. People who come forward for MAID, they are a product of all of their circumstances, including the kinds of services that they have had. But I will just say to you, and this is something that is concerning for a different reason, that the sense that we have is that the majority of people who come forward for MAID have had very positive interactions, for the most part, with the health system. So they are more likely to have been able to take advantage of what the system provides. The people whose experiences with the health system are negative are not the ones, by and large, who are coming forward.
Thank you, ma'am.
MAID.
I just have about 30 seconds left, and I'm curious about the accountability measures that are put in place when the federal government provides funds to the provinces for palliative care, and if that money stays in a palliative care envelope, or if it is blended into administration or promotion of MAID. And so, while I don't think you have time to answer that, I wonder if you might have the ability to provide some of those details to the committee in writing prior to our preparing our report.
I can do that, but I can tell you now, I don't see that money being diverted from palliative care to the promotion of MAID. I think this is completely
okay. Thank you.
Something that's happening currently.
Thank you, ma'am.
Thank you. Thank you. And next will be Mr. Ananda Sangari for 3 minutes.
Thank you, Madam Chair, and I want to focus my question to Ms. Banerjee. Ms. Banerjee, would it be safe to say that from a disability lens that you have extensive engagement with the disability community in Canada?
We do have extensive engagement with the disability community, not specifically related to MAID, but more in terms of the Disability Inclusion Action Plan that the government is working on.
So with respect to MAID, what is the overall perceptions, apprehensions, feelings towards MAID? If you could maybe give us a sense of what the different perspectives are within the disability community with respect to MAID?
My understanding is that the impressions that we have is that there are many different views throughout the disability community. Parts of the disability community are wanting very much to have access to MAID. There are concerns with other persons with disabilities and organizations about making sure to also have adequate access to supports and services. So it's quite divided throughout the community. And I know that a priority of our department and of our minister is to make sure that the different voices are heard through the process.
Can you maybe elaborate on, in terms of, because in the media there's been a number of reports about apprehensions. If you could maybe talk about what kind of fears exist, because with respect to extending MAID to people with disabilities, I know it's been an issue of contention, but it does appear to be inconclusive. So can you maybe give us some concrete suggestions as to what kind of safeguards could be put in? I don't know if you're in a position to do that today, but certainly you're welcome to submit further evidence by writing. So if you could maybe give us a bit more in terms of the type of feedback you received, as well as to talk about some of the safeguards that may be required if MAID is extended.
Okay, 30 seconds.
Yes, I think that that might be better that I look into the data in more detail and can get back to you along with some other follow-ups that I have.
If there's 10 seconds, Madam Chair, I might just add two for Mr.
Yes, go ahead.
Angry to when Bill C7 was passed, the non-reasonably foreseeable death safeguards include a safeguard that requires the person be offered consultations with various professionals, including disability support services. And that was part of what I understand helped respond to concerns were expressed by the disability community. But there's obviously much more that can be said on this issue, and the committee could look to members of that committee and disability rights organizations to provide evidence to inform its consideration.
Thank you.
Okay, thank you. Next, we will have Monsieur Thierot for 2 minutes, followed by Mr. McGregor. Mr. Thierot.
Thank you. Excuse me?
J'ai pas entendu. Qu'avez-vous dit?
Excuse me, what did you say? Thank you. In the report of the Academics Council of Canada with regards to advance requests, it says, and my question is that given that these advance directives can include consent or refusal of some treatments, we can talk about blood products, artificial hydration. So given that advance directives already exist and are regulated and applied in Quebec and in provinces for different medical situations, but that advance requests here we're talking about MAID, so that the regulatory framework of Canada for advance requests for MAID constitutes a federal framework, given that the implementation would also require provincial contributions. So advance requests, given that we already have used to advance directives. So is this not an extension that would cause a lot less problems with regards to practice and implementation?
Monsieur Potter.
40 seconds.
Thank you, Madam Chair. What I might offer is to recall that what the criminal law does is it exempts the practitioner who administers MAID from criminal responsibilities. So the criminal law would need to provide a level of certainty and a level of specificity to understand for the practitioner's purpose when are they able to proceed. And as I mentioned, part of that involves the practitioner being confident that the request remains the voluntary will of the incapable person who's before them. And so part of that goes to the content of the request. Is it clear enough? Is it specific enough? How do we know the request still represents the will? And part of it goes to looking backwards in time when there may have been very different people involved and different treatment teams involved. So I think it's appropriate to note that this can be an area of shared responsibility, but if provinces were, as I mentioned earlier, not to legislate in this area or not to provide a framework, for example, to store and track and maintain advanced directives, it would be difficult for the provider at the time of offering MAID to be confident that the document that's before them was in fact made by the person, that it was a voluntary expression of that person's interest, etc. So if there's not a...
Mr.
Yeah.
Potter.
Thank you.
Thank you. Mr. McGregor.
Thank you, Madam Co-Chair. Very quickly, Ms. Hoffman, does Health Canada have data on the number of people in Canada who are under the age of 18 and suffer from a grievous and irremediable medical condition as is defined in the Criminal Code?
No, we do not.
Is it possible to get that data, or is work being done to obtain it?
It isn't. I think there is some information we could get from the pediatric medical community about incidents, but you could find out information, for example, about pediatric cancer and the outcomes in terms of morbidity and mortality, but not for most other diseases.
Yeah. Yep. I just want to get to Mr. Potter. Mr. Potter, in British Columbia, we have the Infants Act, which defines what mature minor consent is. Basically a healthcare provider can accept consent from a child if they are sure that the child understands the need for healthcare, what the healthcare involves, and what the benefits and risks are. Is it similar provincial law across the board in Canada and the territories? Because if we're going to tackle the subject of mature minors, we have to have an understanding of the provincial groundwork that we're dealing with.
I understand there's some variation. I'd refer you again to the Council of Canadian Academies study, because I believe there actually is a useful summary there of comparing the jurisdictions, but I understand there is variation, and in particular, in some jurisdictions, it may not be as specific as the British Columbia statute you mentioned. It may be more a matter of this is how the case law has evolved and is implemented by common law. So again, I would commend to you the CCA study there, because I think that provides your answer.
Would the criminal code have to entertain such a definition in order to have some uniformity?
So if Parliament wanted to allow MAID for mature minors, then
10 seconds.
It may need to address what is meant by a mature minor. It could do that in relation to provincial legislation, or it may need to set out a specific term. It really depends what the objective of Parliament is in doing that.
Thank you.
Okay, thank you. And we'll go back to the top of the list. I will invite Mr. Cooper for 5 minutes.
Thank you, Madam Co-Chair. My questions relate to the first and second annual reports. Neither report discusses how many incomplete or inaccurate MAID reports were submitted to Health Canada and how those were corrected. So if any of the officials could comment on how many inaccurate reports were submitted and how that was corrected to ensure accuracy.
I can respond to that. I can't give you an exact number, but I can tell you that every report that comes to us for every case from each provider, if there is information missing or it appears that an answer may be incomplete, then there is communication back to the provider, or in the case where provinces are filing reports with us on behalf of all of their providers, there is a conversation that goes on to make sure that the report is actually completed as required. And I will just note that the overwhelming majority of reports come to us from the provinces on behalf of all of the MAID providers who have been active on a case in the period in question. Those provinces often collect additional information of their own. So there is a quality control check on that data before it actually comes to us. So we're pretty confident.
Thank you. No, I appreciate that. That's helpful. But as you note, some data goes directly to Health Canada, not through a provincial body, and the second report that I was reviewing makes reference to an electronic verification system to ensure completeness. But is that it? I mean, I understand that these reports take not more than 10 minutes to complete. So, for example, if the report on its face appears to be complete, and insofar as all of the boxes are ticked, what's the assurance that that report, in fact, is complete and accurate?
Well, look, I think at a certain point in time, you have to have some trust in these providers. And I think that anyone who has dealt with the MAID community of practitioners has been struck by the due diligence that these people exercise.
Well,
if a report is incomplete, we go
that.
back to the person who submitted it.
But how do you know if it's complete or not if there's no additional verification?
Well, we are not out there auditing every single report.
I'm not asking. Sorry, my time is limited. I don't mean to interrupt, but I'm not suggesting that it would be practicable to audit every single report. But surely there must be some additional check in place to ensure accuracy, given the fact that what you're telling me, as I understand, is that there's nothing.
No, I'm not telling you that. I'm not telling you that. I'm telling you that the reports are checked for completeness.
Maybe I'll ask you a specific question, and that is, are there any on-site reviews, for example, of randomly selected cases across the country? That might be a way.
Not conducted by us, but I mentioned earlier in response to another question that there are oversight mechanisms in provinces, that there are quality review procedures, and that the oversight of MAID is generally, in our opinion, quite good. So we are not concerned at this point, and we don't have reason or evidence to be concerned that there are MAID reports being filed by practitioners that have incomplete or inaccurate or fraudulent data. That is not our observation. And in fact, as I say, because of these additional mechanisms that are in place in provinces, some of which are for quality reviews, some of which are for oversight and compliance, we think the system is working pretty well. And I would say also that it takes more than 10 minutes to respond, and the new data sets will be considerably more complex and require more time.
But again, not all of the reporting is going through provincial bodies.
That's correct. About a small proportion of the total number of MAID cases comes to us. Well, it would be represent probably less than 10% of all MAID cases in Canada.
Now, with respect to those cases that are being submitted directly to Health Canada, is there any mechanism in place to ensure that federally collected monitoring data in respect of those cases is being shared with local enforcement agencies as the regulations permit?
30
Mr. Cooper,
seconds.
I think you asked me this question last year, and I think I indicated at that time that enforcement is not the job of the federal government, and it's not the role of the monitoring system. So in the rare occasion or hypothetical occasion, if there was some reason to believe that the report was incomplete, we would interact with the person who provided the report. But we do not have the kind of data that would make it reasonable for us to advise law enforcement. These are responsibilities of provinces. That's very clear.
Okay, thank you. I'm back to my original order for the Liberal MPs, but because there's an even number, it would be Mr. Maloney again for 5 minutes. Is that correct?
I believe that's right, Madam Chair. I'll share my time with Dr. Fry. So.
Okay, thank you.
Thanks. Okay.
For 5 minutes then.
Great, thanks. I'm going to ask a couple of questions quickly and then pass the time over. Ms. Hoffman, thanks for mentioning Victoria. I watched that show you were referring to too, and it was Dr. Stephanie Green who was the practitioner involved, and I believe the number in Vancouver Island was 7%. Do you have an explanation why it's so high? I mean, there could be a greater number of seniors, for example.
I think it's a little bit demography. So the nature of the population, the age, education, and so on. I think the other thing, and I alluded to this earlier, that there has been an incredible effort in that in the health authorities operating on Vancouver Island to make sure that MAID is accessible. And that clearly has made a difference when you combine these two factors of demography, socioeconomic status, and so on, and the availability of a very kind of open and receptive and responsive MAID system.
Thanks. I was asking that in sort of conjunction with the 4% figure. It's not cause for concern, I guess, is really what I'm getting at.
Well, not at this point. I mean, look, there is variability across the country. We know that. Everybody knows the rate in Quebec, in terms of the whole province, is considerably higher than that of Ontario and BC. I think if we saw a rapid spike to 7% across the whole country, which I don't anticipate, but if we saw that, then I think that it might be wise and prudent to look into that. But we're not seeing that as a trend.
Okay, fair enough. And Senator Kuchar asked a question that I was going to ask, which was the percentage of cases where there's a mental disorder involved as an overlay to the other diagnosis. I'm not sure we had the answer to that, but is getting the answer to that possible?
We can try, but I think we don't, under the current data collection system, have good data on that, which it's more focused on the main underlying conditions. But I'll defer to my colleague here, if I may, Madam Chair, Jackie Lemaire, to just quickly respond to Mr. Maloney's question. Jackie, go ahead.
And we're about halfway. Just
yeah, let me put it
this.
I'll leave it this way. If it is available, if you could get it to us, that would be great. And then
okay. Just a quick answer. It isn't. We do indicate where there's multiple comorbidities, but we don't break that down.
Okay, thank you. I'll stop there and turn it over to Dr. Fry.
Thank you very much, James. I appreciate your generosity in allowing me to share this. There are a couple of things. If you looked at the Carter decision and what subsequently became Canadian legislation, and now we're looking to see whether, in fact, things worked, whether they didn't work. Do you have any idea about what percentage, Ms. Hoffman, of people who requested MAID was denied? Or how many percentage of people who requested MAID and then changed their mind? Do you have any data on that?
We do have data, and it's in the annual reports, Dr. Fry. So rather than my expanding on that data, I'm happy to sort of follow up with the actual kind of chart that shows you that information and how it's evolved over the life of MAID so far. But what I will tell you is that the number of requests that are declined is a smaller proportion than one might think. I think it's in the, I'm sorry, I'm going off the top of my head here, but the 15 to 17% range. Now, I will tell you that part of the reason for that is not that MAID practitioners are kind of saying yes to everything. Part of it is that often the interaction that a person seeking MAID will have with a provider leads to a conversation about whether or not they are likely to be deemed eligible. And if they are not, they do not proceed with a formal request. So the refusals that I'm talking about, those numbers are with respect to the formal written requests, which is a little bit different. Now, we also have detailed information about withdrawal of requests or requests that are approved but do not lead to a MAID death. In many cases, that's because the person died before the procedure could be undertaken. There is a very small number, but it's not insignificant, of people who actually withdraw very close to the day or even the day of their MAID request. And they simply say, I no longer wish to proceed. And there's some in the middle who have received palliative care or other support and who simply say, I can carry on. I do not see that I need to pursue MAID right now.
Thank you, Ms. Hoffman.
That is time.
I would appreciate you
Sorry,
sending
Dr.
that graph to us, please. Thank you. You can send it to the clerk.
Okay,
Thanks.
wonderful. Monsieur Thériault, you have 5 minutes.
Merci, Madame la Présidente.
Thank you, Madam Chair. About mental problems, mental issues, when this is the only health problem to show how difficult it might be to pass a law on that. But in the same report of the Canadian Council of Academies, that the challenge for certain people who ask for MAID when they only have mental issues is that this could be a symptom of their disease, of their health problem, and certain mental troubles might lead to a wish to die, and it might be difficult for a provider to make a decision between such a person and someone who is seriously ill. And when I read this, I really want to read the report, and we need to hear those experts to tell us how we can get out of this kind of problem. What do you think of that?
Absolutely, and that is precisely what the panel has set out to do. These are undoubtedly complex and difficult decisions, but I think it's important not to enter into the discussion with, if I may use this word, biases. The fact of the matter is that some mental illnesses manifest as a symptom suicide, an impulse to commit suicide. But the overwhelming majority of mental illnesses do not have suicidality as a symptom or a characteristic. So we need to be sure. And look, I shouldn't speak further about this. The experts on the panel will, I'm sure, be happy to meet fully with this committee. They can tell you more about the professional practice that lies behind the kind of point that I've just made, and other means to clinically assess a person relative to the MAID criteria that are, and eligibility criteria and safeguards that are in place today.
Oui, bon, on sait que l'état suicidaire est réversible.
Yes, we know that the tendency to suicide can be reversed, but according to some research, it might be difficult to determine what it is in view of the various states of the illness, mental illness. So we have a lot of work to do, and I think we'll be rushed to make decisions in another matter. For mature minors, I was asking if in our experience, and we don't have a whole lot of data in the Netherlands or in Belgium about providing MAID to mature minors. What protections exist at that level in those countries?
Very quickly, I'd refer you again to the Canadian Council Academies report because it overviews those jurisdictions. But in the Netherlands, for instance, to your earlier question, Ms. Uterio, if you're between 12 and 16, parental consent is required. If you're between 16 and 18, the parents must be consulted, but they don't have a veto. So I hope that answers your earlier question, but generally I'd refer you back to that report as a starting point.
And I'll just add, if I may, Madam Chair,
non, je sais,
in
je
some
l'ai lu,
countries,
mais allez-y, Madame Hoffman.
Sorry, I just was going to note very quickly that in some of the Benelux countries, the only minors who are eligible for an assisted death are those whose condition is terminal. So there would be no equivalent to our situation of people whose death is not reasonably foreseeable.
Okay, that is 5 minutes. Thank you. Merci. Lastly, we'll have not lastly, but the next 5 minutes will be Mr. McGregor.
Thank you very much, Madam Co-Chair. Maybe I'll turn to Ms. Banerjee and ESDC. I guess what I would like to know from persons who live with disabilities in Canada, from your viewpoint and the feedback that you receive serving this population, what's the main feedback you get in terms of the obstacles that are in their way for achieving real quality of life in Canada? Anything that you can help inform the committee in our work on this very sensitive subject?
I guess we've like I said, we've been doing more engagement more generally on disability inclusion rather than MAID specifically. And also we have kind of relationships with a number of stakeholders. And certainly like financial security is a concern. The impacts that the pandemic has had on persons with disabilities is a concern. And all of this is serving to inform the work that we're doing on a disability inclusion action plan. They also talk about barriers and obstacles, whether they're attitudinal or physical, and so we're taking all of these into account in going forward with the disability inclusion action plan, and in terms of developing the Canada Disability Benefit that was announced in the 2020 speech from the throne.
In trying to achieve that inclusion, do you think the responses lean more heavily towards financial security, or is it in general supports that are available, whether that be access to services, mobility, access, etc.? Can you illuminate that a little bit more?
I think the overwhelming concerns that have been raised have been with respect to financial security, employment, so very heavily weighted on that. Certainly in more general terms, the access to programs has been raised, and just ensuring that anything that we do federally, whether it's a disability benefit, that has an overall beneficial impact on persons with disabilities, so that they don't lose other supports that they may be eligible for.
Thank you very much. And Ms. Hoffman, on the subject of palliative care, from Health Canada's 2019 action plan on that subject, one of the goals is to foster improved access for underserved populations. I guess, do we have an idea as to, what that gap is currently? Like how much more is required so that, Canadians, no matter what part of the country they reside in, do have fair and equitable access to palliative care? Do you have an idea as to the timeline that is going to be needed to achieve those goals, and how much more funding we do need to earmark to ensure that is a reality?
I don't think I could respond, Mr. McGregor, with kind of real data that says, here's the actual gap. We know there are gaps very significantly when it comes to the provision of palliative care in people's own homes. So people who are needing palliative care but are not, their situation is not such that they need to be hospitalized. So we're also taking a bit of a sectoral approach through various initiatives and projects and money that we received in budget 2021. They're all designed to kind of deal with some of those gaps that were identified in the action plan. With respect to underserved populations, not surprisingly, Indigenous communities are significantly underserved. There was a special allotment of money near the beginning of the initiative that's aimed specifically, and we work with Indigenous Services Canada and Indigenous groups to find the best ways for the allocation of that money, but that is not, those are not decisions taken so much by us. They're more done in conjunction with the communities and ISC. So
30 seconds.
The data you're looking for, I can ask my colleagues if we can speak to that, but I think the gap is not documented in the detail that I think would be great to have and that you're requesting, but I don't think we have it. I'm just looking to my colleagues to see if anyone wants to answer, but or to add anything.
I would agree with that. We don't have the data on the size of the gap. We do know that it is large, and we're working with provinces and territories and partners to see how we can fill those gaps together.
Thank you.
Okay, thank you.
Okay, so folks, we have 11 minutes remaining, and we have 12 minutes of question time left from our senators. So we'll just be strict with our time, and we're going to begin a 3-minute round with Senator Meiji. Senator?
Thank you, Mr. Chair. My question has to do with mental illness. Oftentimes, there's a link between mental illness and social inequality. What precautionary measures were taken in other jurisdictions for these people? Can the federal government invest to increase access to better support services for people suffering from mental illness? Perhaps this could assist people before they arrive at a request for MAID. I'm not sure who wants to tackle this question.
Well, Senator, maybe I can start just by saying that we know that the panel has looked very closely at measures taken in other jurisdictions when it comes to safeguards for dealing with cases involving mental illness. And I think rather than my trying to speculate on what the panel will say in their report, I would ask that you wait for the report and the opportunity to question the leaders of the panel.
Thank you.
You have 1 minute.
Vous avez...
Going to yield time or continue?
Non, je peux passer mon temps à un autre.
Yes, I'll yield my time.
Thank you, Senator. Kutcher now for 3 minutes, please.
Thank you very much, Chair. Question to Ms. Hoffman. You mentioned earlier in the discussion about consensus that consensus around MAID has not been a phenomenon all the way through this process. Is there any way that you could give us some idea of the numbers, what the proportion of medical practitioners, say when C14 came into place, were comfortable and supported MAID, and what percent didn't, and in the palliative care community, what that proportion was when MAID was first introduced, and then has that changed over time? Has there been a change in the consensus over time?
Sure. So look, first of all, I think when MAID first came in, there was a small critical mass of providers who were ready to proceed. There were individuals who had kind of done everything but assisted dying with their patients at the end of life, and they were ready to proceed. But fairly quickly, we got to the point where there are close to 1,500 providers now and assessors. Not all of them are doing, numerous cases. Some are doing relatively few cases. I can tell you that going back to the outset, surveys that were done by the Canadian Medical Association, for example, in their own community indicated not unanimity in favor of MAID, but relatively high support, but support for MAID and willingness to be a MAID assessor or provider. Those are not exactly the same things. But what I think we've seen is an increase in receptivity to MAID generally, an increase in the number of individuals who are prepared to take on MAID assessment and provision functions. We know that there is going to be, I think, a pause, shall we call it, as providers are starting to receive these so-called Track 2 cases, and some may give serious consideration, not It could be partly because they have some reservations about providing an assisted death to someone who's not dying. It may equally be because they know a particular specialized skill set is required. And unless they want to become a kind of specialist MAID practitioner, this may be a route they don't want to go. And that's why I mentioned earlier, we've already seen this trend where some practitioners are doing more cases, and we expect that is going to be a significant place for growth into the future. So I can't tell you exactly how many were agreed and how many were opposed. I think people's views change over time, and that has happened in the medical community. We have seen that.
Thank you very much.
Thank you, Senator. Thank you, Ms. Hoffman. We'll hear from Senator Dalphond. 3 minutes, please.
Merci.
Thank you, Mr. Co-Chair. My question is for Mrs. Hoffman. I understand the right to self-determination, and in some cases, some people are suffering from mental illness, and they would want to have their file dealt with individually. But as for the policy, would it not be more acceptable for Canadians to accompany this change with a greater amount of funds allocated for treatment of mental illness in society? We saw during the pandemic that resources were not sufficient.
Well, look, I think as a general matter, clearly when we have an area where it's widely recognized that the services are not sufficient, it would make sense to have more services available and for those services to be better resourced. But let me just note, though, that when we're talking about MAID in cases where the sole underlying medical condition is a mental illness, these are likely going to be cases that have not responded to treatment. If you look even at the regime that is in place now for cases where the person's death is not reasonably foreseeable, and then you think about what you will hear inevitably from the expert panel about additional safeguards, I think what you'll start to see is a picture of access to MAID for people who have a significant mental illness, where there's been an extensive review of all of the treatments and supports and interventions over a long period of time. So these are more likely going to be individuals who might be considered for MAID who have had the benefit of an extensive interaction with psychiatric care modalities. These are not the people who all of a sudden, some newly diagnosed bipolar disorder or something like that appears, and a month later they show up on the doorstep of a MAID practitioner with a request for MAID. Anyway, the expert panel will talk in their expert fashion, not my sort of vernacular version, and will describe all of this. But
30 seconds.
I think these are almost they're related issues, but they are somewhat different issues. The general availability of mental health and wellness services, and the situation and the access to treatment for someone with mental illness who gets to the point where they're seeking MAID.
Merci.
Okay, thank you, Senator. Next, for 3 minutes, we have Senator Martin. Go ahead, Senator.
Thank you, Mr. Co-Chair. I have one question for Ms. Hoffman in regards to palliative care. We did hear witnesses. I'm a British Columbian regarding the not a competition for funds, but that sometimes funds were being directed for MAID that perhaps should have also either been made available to palliative care, but there's a bit of a competition for funding. But my question goes back to what Mr. Barrett asked, which is it possible for the federal government to be in touch with the provinces to find out exactly what is being spent on palliative care versus MAID? Is that information something we could ask you to come back to us with or send to our committee?
I'm going to ask Venetia Lawless to respond to that question, Senator Martin, if I may.
Thank you.
Thank you. So if you're referring to the Common Statement of Principles bilateral agreements funding, we do have broad strokes understanding of how much is being spent on palliative care through their action plans that they have agreed to. and those are all public documents. It's hard to pin down exact amounts of money. For example, in Ontario, the money came in and ended up merged into a pot, which is their full home and community palliative care expenditures. So it includes their own provincial funds, because there's a lot of crossover. So we don't have exact numbers, but we can certainly get broad strokes of how much money is being spent on the palliative care envelope for that allocation. And we would follow up and provide it to you.
Okay, that would be helpful. And I guess it is about the accuracy, transparency as much as possible so that we know that palliative care is not having to compete in any way or funding is lost as a result of increase made. Thank you very much, Mr. Kocher. I'm done with this time. And so at this time, as a committee, we'd like to thank all of the officials who made presentations today, answered our questions. We wish we could have many, many more hours with you, but for today, thank you very much. And we will move shortly to the request from Mr. Anasangari, I think I mispronounced that, to have a discussion in the final 15 minutes of our committee. Thank you, witnesses.
Thank you, Madam Chair.
Thank you very much, Madam Chair.
Thank you very much.
And before we get into the final discussion, I want to just remind all members to submit your suggested witnesses to the joint clerks by tomorrow, 4 p.m. Eastern time. So it doesn't give us much time, but I know we've all been working on these lists already. And the clerks and analysts will review and compile the list of witnesses for the committee's consideration. So tomorrow deadline is 4 p.m. Eastern time. Okay, so now I will invite Mr. Anand to bring to us the item that we had agreed to look at in these final 15 minutes.
Thank you, Madam Chair, and thank you, colleagues, for the indulgence. I believe just given the short nature of the time that we have to complete the study and to table it by June 23rd, I think it'll be important to have a subcommittee meeting where the witnesses could be both finalized and prioritized, as well as some agreement on what the number of meetings and what availability we have with the House resources for those meetings. So I'm proposing that, and I don't know if this needs to be a formal motion, but I'm proposing that we have a subcommittee meeting next Wednesday, which is the 20th, from 1:30 to 3:30 to discuss the matter. And then the first, I believe the House availability for the meeting would be on Monday the 25th. And at that meeting, we could submit the report and have it approved by members and continue with our witnesses. And I just wanted to canvass what people feel on this, and a deeper dive could take place on Wednesday, so we can actually hammer out the work plan for the next few weeks.
Okay, thank you. So the motion is for a subcommittee to meet next Wednesday, April the 20th, at, did you say 11:30 a.m.?
1:30 to 3:30.
Oh, 1:30 to 3:30. Okay, thank you. Any questions or comments before we ask for your consent? Seeing none, I think that is approved. So we will have a subcommittee meeting next week on April the 20th. For that subcommittee meeting, I'm just wondering did we get the nomination of the additional Liberal member to sit on the subcommittee? And we can also confirm that from the Senate, we have agreed on Senator Kutcher to be a part of the subcommittee. Do we know which additional Liberal member will be part of the subcommittee?
I would be prepared to serve, Madam Chair. If the committee wishes, I would be prepared to do that rep.
Is there such a motion or
I will move it,
acceptance
Madam
of the
Chair.
offer? Oh, Mr. Maloney
Acceptance, as
moves.
the case may be. Yeah.
Okay. And carried. Okay, so colleagues, thank you again. It was a 3-hour session, but we all were able to keep to our time for the most part. I appreciate the work of the clerks behind the scenes to get us ready for today, and to all of our staff that have hard as well. So happy Easter, happy holidays to everyone, and I know you're working hard in your constituency weeks as well. Thank you, and I declare this meeting adjourned.
Thank you.